No, I don't. Oh, wait a minute. Yes, I did. I'm just waiting for them if they're ready. Yeah. Okay. All right, on this case, I know that Mr. Cabanas was recently appointed because Mr. Chavez is a Spanish speaker. Where are we on discovery?
Your Honor, my understanding right now is that defense was, had just confirmed with immigration attorney and that they were waiting on PA letter.
Okay,
So, yes, Your Honor, to further explain, we have all the discovery videos and documents. We just met with the MAC immigration attorney for the second time because my client has a pending immigration process or immigration attorney.
Mhm.
And so he's in the process of giving me an explanation of what that process is like, so I could then forward it to the MAC immigration attorney. And then Padilla letter can be written.
okay. So when is this letter going to be written?
The Padilla letter,
Mhm.
as soon as his current immigration lawyer forwards me what that immigration petition is about, I'll forward it to the MAC attorney. So I'm hoping by next week, Judge.
All right. So this is going to be the last setting for immigration issues. I'm going to recall it for June 27th. Is that good for you?
Yes, Your Honor.
And once I give you the reset form, you're excused.
No.
All right, thank you. Once you sign the reset form, you're excused.
Judge.
You're welcome.
For your signature, Your Honor?
Oh, yes. You'll give it to the clerk and she'll pass it to me.
Yes.
Thank you.
Thank you.
All right, Marie Miles.
We're present, Your Honor. I've conferred with Zach and.
Oh, where's Miss Miles?
Is here.
All right, it should come forward.
Ms. Miles?
Yes, come forward. All right, where are we on discovery?
I think we're good on discovery.
Yes.
Were you able to tender an offer or no?
Well, we are of a slight, we're not entirely sure. Counsel believes that they have some information as to the potential cooperativeness of the complainant. We have other information. And so through conferring, we would like to kind of ensure that we both have a clear understanding on
Of where the parties.
where they stand.
Yeah.
All right, so counsel, you're going to be in town on June 20th?
Yes.
All right, so on June 20th, you all need to have worked that out. And on June 20th, state you'll need to be prepared to
Absolutely.
tender an offer.
Oh,
Yes,
wait,
Judge.
wait, when is, okay, so when will you be back? I'll be back on the 26th. Can we, should be out of town with permission, I believe from pretrial already. Should be back after the 26th.
All right, the 27th?
Sure.
All right, we'll be back on June
Would that be
27th.
okay? Make it.
Thank you,
Yes.
Judge.
All
Thank
right,
you,
you're
Judge.
welcome. Once you sign the reset form, you're excused.
Okay, just have a seat. I'll bring you the.
All right, so this needs to be set on a day that it is going, because there will be no further continuances here. And I'm going to send a notation to, if this goes to impact, I'm going to send a notation to them that there's not to be any further continuances in this case. So state, what are your dates?
In terms of which month, Your Honor, would you like to?
Let's see what's happening in July or June.
Or in impact July 1st that month?
Okay,
Judge, I have vacation the 4th of July.
all right, June. All right, this is what I'm going to do. We're going to recall this case back. Everybody needs to be here at 9. We're going to recall it back on June 3rd. On June 3rd, I'm giving you all a date, and that's when it's going to be going to trial. Does everyone understand?
June 3rd, a date. Yes, Judge.
And I'm going to give you a reset form. And then we'll be back. And on June 3rd, you all need to confer on a date.
Okay.
And let me just tell you, no date past August. All right, once I give you the reset form, you are excused. All right, court is calling 2022 CR 7283, State of Texas versus Christopher Brent Davis. Can I have parties announced for the record for the state? For the
Robert Barron
defense?
For Mr. Davis.
Suzanne Kramer also for Mr. Davis.
All right, Mr. Davis, you entered a plea on May 7th of no contest. The court found there was sufficient evidence to find you guilty. The court deferred finding of guilt. You're coming open to the court. Have both parties had a chance to review the report from probation?
Yes, Judge.
Yes, Judge.
Any objection, state,
No, Your Honor.
defense?
I have a couple of corrections, Judge.
Yes.
Regarding his discharge from the Navy, it was stated in there that it was less than honorable. I think his actual discharge was a general under, what's it called? Under honorable.
Okay.
General under honorable, not less than.
Okay.
And at the very end where he states a few things he wanted you to know, he referred to something that happened to him at age 5, but a subsequent conversation with his mother that was determined to have happened when he was at age 2.
Okay. All right, any witnesses?
Not from the state, Your Honor. We just have an argument.
Just Mr. Davis, Judge.
All right, could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do have a couple other witnesses. Can we take them first, Judge?
Sure.
Thank you. I'm sorry.
All right, call your
Let's
first
call
witness.
Edith Davis.
All right, Edith Davis,
Stand on yours.
can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you're gonna need to keep your voice up so the court reporter can hear. Could you state your name for the record?
Edith Davis.
All right, defense?
All right. And Ms. Davis, are you Christopher's mother?
I am.
All right. And I think you may have heard me state just a minute ago about something that happened to Chris that you said happened at age 2.
Yes, sir.
And can you explain to the judge what happened and how that turned out?
So our babysitter was leaving. We were looking for a new sitter. My husband's getting ready to go to Korea. We found a lady that was in the neighborhood. She had 2 other children that were a little bit older. I had come early one day and found their children throwing rocks down on my children. Christopher was almost 3, not quite. Then when I got, found out she was giving them dog treats for cookies for their snack. And I had known that both my kids, Kristen was disabled, but Christopher, very active, gotten very, very afraid of when I was cleaning house. I didn't understand why, but when I had talked to my daughter, she told me that the kids would take the vacuum cleaner and suck on Christopher with it and tell him that he was going to suck him up and he would suffer. So when I saw what was going on at the house, I immediately removed him from the house. I found my next door neighbor was going to take care of them for me. So it took a little while to get him a little bit more calmed down, but it was pretty traumatic for them.
And did you have a statement that you wanted to read for the judge?
I do. That's okay.
All right, state, do you have any objection to the reading of the statement or would
Sure,
y'all?
statement, Judge.
Well, I mean,
I know.
it's technically, it's a narrative, but if you all want her to read from it or counsel, if you want me to read it,
I have no objection.
all right, you may proceed. That's okay. If it would, if you want to, I can actually read it.
Thank you, Judge.
All right, you're welcome. No problem. Just give me a moment. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Michael Davis.
All right, defense.
All right, Michael, are you Christopher's father?
Yes, sir.
We've had some conversation about this scenario and it's my understanding that you feel like maybe you could have done something different and would have avoided all this. Can you explain to the judge what you're?
Yes, ADHD runs in our family. I was never diagnosed, but I've had issues with it my entire life. I'd learned to deal with it. When Christopher finished high school, he quit taking his medication. And when he joined the Navy, if I had called the reservist office and told them that he was ADHD because I know he didn't tell them. They would either rejected him or kept it, had him take his medication. His whole life would have been different. One phone call, if I'd made it, wouldn't be here. So, love my son. I know he did wrong, but that's all I've got, ma'am. I'm sorry.
No, I appreciate you coming in to testify.
I don't have anything further, Judge.
Any other questions?
No.
All right, thank you so much.
And Judge, at this point, I just have Mr. Davis.
All right, so raise your right hand for me. Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Christopher Brent Davis.
All right, defense.
All right, Christopher, what is it that, other than what you already stated in the PSI, what is it that you would like the judge to know before she decides what your sentence ought to be?
Your Honor, there is no explanation. There's no rhyme or reason. Nothing would be able to be justified as far as what my actions did. There's every day that I live with regret because it's not only one person I hurt several people, including my own children, my own biological children. The only thing I can ask is for forgiveness from them, and I will accept whatever consequence that you seem as punishable, Your Honor.
All right.
And Judge, this is the part where I do, like I tell my wife, if I tell you something from here on out and that you can accept it two ways, one to make you mad and one to make you not mad, I mean the one that makes you not mad. Okay. So, question that we have is what's appropriate punishment for this type of case for
All
Mr.
right,
Davis?
I'm sorry, just 1 second. State, you don't have any questions, do you? All right. All right, thank you for giving your testimony. And so the range of punishment for this offense is 5 to 99 years or life.
That's correct, Judge.
So state, what are you requesting?
Do you want my request and my argument or just my request? Right?
Your request.
You're asking for life, Your Honor.
All right. So they're asking for life. Defense, what are you going to be asking for?
Judge, we're asking for 20.
All right. So now, state, I understand why you're asking for life. Defense, I understand why you're asking for 20. So, one, I'm not going to sentence him to life. I've taken in consideration his testimony. I've taken in consideration the testimony from both his parents. And I want the parents to know, at some point in time in life, your actions are not the cause of your child's actions. Because how old are you?
38.
All right, so he's 38. At some point in our lives, when we're making our decisions, no matter what happened in our past that was horrible for us, or maybe our parents made a mistake in how they raised us, at some point, your actions are your own. All right, so I'm not going to sentence you to life, but I'm not sentencing him to 20. It's an egregious offense.
And if I may offer some perspective on that, Judge, that's what I
Yes.
intend to do. So we agree it's egregious offense. He agrees it's an egregious offense. It's something that went on for about 6 or 8 months from what we can tell from stipulated evidence. And yet the same day that we were pending, that we actually entered our plea, there was another person pending who's had a death of a child, injury to a child causing death. And the very next day, this same prosecutor's office, same prosecutor
I'm gonna object to this line
offered
of,
them 18 years.
All right, okay, so here's the thing. Defense attorneys, you all know that sometimes people can be at the Bear County Jail or at the prison. Sometimes there are people at the prison for murder, they get 5 years. Somebody else at the prison for murder, they get 30 years. Every case is different, and there's a reason why people are given certain times. And there are reasons why sometimes this court follows a plea, sometimes that I do not follow the plea. Now, what I'm telling everybody, the state has asked for life. State can ask for whatever they want. I've already told the state, I'm not giving him life. So the argument about what they did in other cases, that's not an appropriate argument. We're here for this. Now, if somebody wants to make an argument that the same fact scenarios, as we would call it in law school, that the case is on all fours, if there's another case that's on all fours with this case, where the state gave somebody 12 years or 10 years, then we need some explanation, because maybe things are not being done fairly. So if you can present a case to the court that's on all fours with this case where the state made an offer of something less than life, I think it's relevant. I'll hear it, because maybe something else is happening in the office.
Well, Judge, and I would offer you something on that. I think it's on all fours. I don't know whether it's on all fingers and toes, but there was a case in the 227th where the fellow was charged with continuous sex abuse of a child, same as Mr. Davis. He was allowed to plead to aggravated sexual assault of a child, same as Mr. Davis, but he was given 12 years.
All right, so
For a 4-year-old child.
So let me ask you this. Was that a case where you had a defendant who's alleged to have pretended to be a juvenile online and then tricked his stepdaughter into allowing him to engage in sexual activities with her by pretending if she didn't, the new friend that the defendant had created, life would be in danger?
Of course, Judge, I cannot offer you that, but they just, for selective prosecution purposes and sentencing purposes, substantial similarity, I think, is what they look for. And in this case, the same charge, same reduction, a 4-year-old instead of a 14-year-old, and this fellow gets 12 years and the state wants life. I know you said you're not giving that to them, but this guy gets 12 years in a different court, and Mr. Davis is looking at whatever that you choose to give him. So
Okay.
that's the only reason I'm offering that, Judge.
Right.
And again, back to I'm not trying to make you mad.
No,
I
here's-
don't want to visit my sins on my client.
No. Here's the thing. One, I don't get mad. I believe that everybody should be allowed their argument. I've been a defense attorney before. People should be allowed their argument. I've been a prosecutor before. People should be allowed their argument. I don't get mad. And what I can tell everybody, when you're in jury trial, if this were a jury trial, guess what? Defense counsel's state's closing arguments, that's not evidence. Evidence is the steps that I have. Evidence is whatever testimony I receive. Closing arguments that counsel do on both sides, that's spin. And hopefully the arguments they're making is in some form or fashion connected to the case that was just heard. All right, is there anything else?
No, Judge, I would just like to highlight, there is one other statement from Christopher in the pre-investigation report at the very last page. It states that he was the subject of a grooming himself when he was around 12 years old by a 39-year-old. We've discussed this, and again, Judge, he's not of the opinion that is any excuse for what happened, and he doesn't even really know if it lent any any substance or predisposition for him to have done this, but it's just offered for the court for contextual purposes.
All right. So I want to let you know that I heard all of the arguments. I internalized everything. And these are very difficult cases. Anytime someone comes open to the court, it's very difficult. And let me just tell you why it's difficult. This is the type of case where everybody will say automatically it's a life case, right? But I go on facts. I go on what I read. I go on everything. I go upon, experience I've had in dealing with specific cases. Because otherwise, if every case were a life case, then guess what? We don't even need to have a punishment hearing. It's just, this is what you did. We proved it. You get life automatically. So I look at everything. What you've done, of course, is something very bad. And people are going to be impacted for years to come, right? So sometimes when I consider what to sentence somebody to, I think about their age, I think about protecting of the public. And there are many things that I have to consider. Like, for example, is somebody going to allow you to be around children again? That's something I have to consider. Like, what age will you be where people will see you and they will not say, oh, that's a good catch. Let him babysit a child. Those are all things that I have to consider because part of my job is protecting the public. And I also have to consider evidence that's presented. I consider the stipulations that you stipulated to. So this is what the court is going to do. Court is finding you guilty. There's to be no contact with the complainant. There's to be no contact with any minor. There's to be Chapter 62 registration. Court is going to sentence you to 45 years. Court will give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Your
All right, we can go off the record. Here's the thing. I want to let you know, just a second. I want to let you know that I appreciate the fact that you entered a plea to this, you entered a plea to it early, that when you came before the court, you didn't try to be wishy-washy on whether you did it or not. You are a person who truly took full responsibility for what you did. And I appreciate that you did that. All right, so can you mute us, please?
I feel you not only need for me to apologize for things that you did to me, but to the rest of my family and to these kids. And I hope that you pray hard for that and that one day they can forgive you. But I also want to sit here and say thank you in a roundabout way, Chris, for everything that you've put me through, but because you've not only made me a stronger woman, but you've made me a stronger mother when it comes to protection of our kids. The kids have decided that they wanted to say something to you. Our daughter states that to me, you were never really my father, only because you treated me like I was nothing, for always lying and never listening when I told you the truth, for robbing me of my childhood and making me have to grow up too quickly.
All right, excuse me. I'm so sorry. The defense has raised an objection. I'm going to sustain that objection. Thank you so
Okay.
much for coming in to give your statements.
Thank you.
All right, thank you. All right, thank you.
Thank you.
All right, Amber Salazar, do you have
That's
all the
fine, Judge.
discovery?
Everything that's uploaded, Judge, this is first setting. So we have we conferred, and I believe I have all the discovery.
All right, so we'll come back on June 27th. On June 27th, states you need to be prepared to tender an offer.
Yes, Judge, and defense did bring up an issue for me to look into, so that's kind of why.
All right, is that enough time?
Yes.
I think that's.
All right, once she signs the reset form, you're excused.
Thank you, Judge.
You're welcome. Thank you. Thank you. Thank you for dressing appropriately. John Alberto Casanova Pius. Hello. So on this case, we're going to come back on June 3rd. On June 3rd, you all going to get your jury trial date.
Okay.
All right, so let me give you a reset form. And once you sign that, you will be excused. All right, is there any other outstanding issues that need to be discussed?
No, ma'am.
All right, so we'll come back on June 3rd. Once you sign the reset form, you're excused. Thank you for dressing appropriately for court.
Sure. Do you have the reset form there?
Yes.
Okay. Thank you.
Be on this restitution hearing? All right. So,
Okay.
just give us 2 more minutes.
Okay, Jen.
Hi, so you have all the discovery. Has the state been able to tender an offer?
They have, Judge, and they're finished their discovery issue. An issue came up today on our end that I need to investigate. Actually, a couple of issues that I need to investigate that have to do with some research that's gonna have to be done and some investigation.
Okay. Let me see here. I'm calling you back on July 8th. That is going to be your plea deadline date. So any investigation that you need to do will have to be done by that date. Is that enough time?
I would hope so, Judge. If not, I'll file a continuance and advise the court.
Okay. All right, once you sign the reset form, you're excused. And Mr. Taylor, you need to make sure that you're on time for court. You understand?
Yes, ma'am.
Thank you. Maybe excuse.
once he signs the reset form. Counsel, have you received all the discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, sir.
Counsel, do you waive the reading of the indictment?
Do Your Honor.
State, are you proceeding on the indictment as presented?
Your Honor, we're proceeding on count 1 intox manslaughter and count 4 aggravated assault with deadly weapon.
Did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Judge.
All right, off the record. So state and defense, if y'all will write here that the intoxication manslaughter is count 1, and then just do a comma, count 2, aggravated assault with a deadly weapon. So,
Yes, Judge.
Okay.
Sorry about that.
oh, no problem. So did you understand in count 1, you're charged with intoxication manslaughter, and count 4, you're charged with aggravated assault with a deadly weapon? Those are second-degree felonies. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine in each count. Did you understand?
Yes, Judge.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Judge.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Judge.
Did you understand by entering this plea, you were giving up those rights?
Yes, Judge.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Judge.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Sir, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Judge.
Has anyone promised you anything other than the plea?
No, Judge.
Are you satisfied with the way you've been represented?
Yes, Judge.
Are you a U.S. citizen?
Yes, Judge.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Off the record for a moment. This is attached to the court's file.
Was it a CD here?
Yes.
It should be.
Yes, Judge, that should have been in the stipulation.
Okay. All right, we're back on the record. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Judge.
According to the plea, you're to plead to counts 1 and count 4. Punishment is to be assessed at 12 years in the prison. There are no applications. And if you are not present for sentencing, you're subject to the full range of punishment. Did you understand? That would mean that if you do not appear, then your plea would stand and the court could sentence you to the full 20 years. And that would still be a part of your plea bargain agreement. Did you understand?
Yes.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Judge, the only thing I didn't hear you mention was the affirmative finding of a deadly weapon.
Yes, there's an affirmative finding of deadly weapon. Did you understand?
Yes, Judge.
Defense?
Yes.
Did you review the paragraph entitled waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Judge.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, sir.
Counsel, are there any such motions?
No, Your Honor.
Then to count 1, how do you plead? Guilty, not guilty, or no contest?
No comment.
Count 4, how do you plead? Guilty, not guilty, or no contest?
No comment.
State any evidence.
State offer states exhibit 1 and all attachments.
No objection, Your Honor.
Did you review the document entitled waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Judge.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Judge.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will find you guilty in count 1. Court will find you guilty in count 2. Count 4. And the court will find there is an there is an affirmative finding of deadly weapon. And you are requesting that sentencing be at a different date, counsel?
Yes, Judge. What I'd like to point out to the court, even though it looks like this is a really old case, it just got indicted this year, 2024. We had a plea deadline very recently. We finally got a plea offer. We reached a resolution
fairly quickly for a case of this nature. And I'm telling you all that so that you would understand my client didn't have a whole lot of time to start getting his affairs in order. He totally understands the admonishments in the plea agreement. He's single. He needs to dispose of his assets. He needs to leave property with his family. He's been self-employed for many years, and so he's closing down the business. So there's a lot of things that have to be done. We're asking for a date in July, Judge.
All right, I'll give you July 27th. We'll see where we are at that point in time.
Perfect.
All right, is there anything else from either side?
Very well.
All right, once you sign the reset form, you are excused. Where are we on discovery?
Discovery, I think we're in good shape, Judge. The real kind of crux for this case is complainant was a fugitive with their own pending case, and I think they've come back to join us. And so we'd like a small update to see kind of where we're at with them with regards to this case, Judge.
All right.
We shouldn't need much.
How much time are you asking for?
2 weeks.
That's fine by me.
All right. And this will be the last date for you all to get in touch with your complainant. So I will set it for June 17th. Once you sign the reset form, you're excused.
Thank you, Judge. We appreciate it.
All right, you're welcome. All
Morning,
right,
Judge.
good morning. This is Criminal Trial Division. Have you received all the discovery?
No, Judge, I tried to download it or review it, but it's down. It's been down for a while. You tried to get
Oh,
on
because
it.
they're doing
Something.
something with
So you
the,
tried to get it and it doesn't upload the page. And sometimes it does, but it's getting very difficult. And there's a bunch of videos on this case.
all right, we're gonna recall it on June 13th for discovery. Once your client signs the reset form, he can be excused.
Thank you, Judge.
You're welcome. Court is calling 2020 CR 5704B, State of Texas versus Tyrese Jackson. Can I have parties announced for the record for the state? Defense,
Sharon Thorne, the defendant.
are you Mr. Jackson?
Yes, ma'am.
All right, did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes.
Are you the same Tyrese Jackson who was placed on deferred adjudication in 2020 CR 5704B for the offense of robbery on July 27, 2020 for a period of 4 years? Is that you?
Yes, ma'am.
State?
Yes, Your Honor. Violate condition number 2, on or about the 11th day of April 2024, Door County, Texas, the defendant Therese Lorraine Jackson did then and there illegally use a controlled substance, namely methamphetamine, violation of condition number 2.
How do you plead to that? True or not true?
True, ma'am.
We'll waive the remaining violated conditions, Your Honor.
Any objection?
No objection.
Did you understand by pleading true to violation of condition number 2, court could find it true, grant the motion, find you guilty and sentence you up to 20 years in prison? Knowing that, do you still wish to plead true to violation of condition number 2? Court will find violation of condition number 2 true. Is there a proposed agreement? Yes.
It is to grant the motion to adjudicate and revoke the individual and assess 4 years of the Texas Department of Corrections.
Is that the agreement?
That is the agreement, Your Honor, and in conferring with the probation, I discovered that he has 859 days credit and he has 275 days credit for safety. And I am requesting of this court that you grant him all those back time, including the safety time.
Did he successfully complete safety?
Yes, ma'am.
Yes, Judge.
All right. Then the court will find violation of condition number 2. The court will find you guilty. The court will grant the motion. The court will sentence you to 4 years in the prison, give you credit for any time served, and I'll give you credit for the time you spent in safety. I'll request the therapeutic community.
Before it's time for me to walk up, is it okay for me to speak to you?
Okay, just 1 second. So I'll give you credit for any time served. I'll sentence you to the therapeutic community, and I'll give you credit for any inpatient treatment time. Is there anything you wish to say?
No, the last time we spoke was when we was at the graduation at drug court. I apologize for not succeeding like I told you I would. I had fallen out. I found out my oldest daughter wasn't mine and I fell. I couldn't cope. I couldn't hold in my feelings, and I do want to apologize because I know you have faith in me.
Okay, I appreciate your apology, but you're gonna have to start doing better. Otherwise, you're gonna find yourself in and out of prison. When you're released from prison, this drug problem will still be there, so you need to take care of it. When you're released, if you can't find some place to go, if you come back here and I'm still here, I'll direct you to a place. You understand?
No.
All right, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you.
Thank you, Your Honor.
You're welcome. All right, who's here on state on this case? Were you able to tender an offer?
Yes, Your Honor. Offer has been, which cause number is this, Judge?
This is 11510B.
Bravo, offer was given to Mr. Delgado.
All right, so your plea deadline date is going to be June 27th. At that point, you'll need to let the court know whether or not you're accepting the offer that has been tendered. If you all are not able to work out an agreement, then you will be given your jury trial date. Does everyone understand?
Yes, Your Honor.
One day, I promise I will learn how to pronounce your first name.
It's fine, Your Honor. This is your courthouse.
No, as they say, it's the people's courtroom. All right. So that will be your plea deadline date. All right, once you sign the reset form, you're excused.
Awesome.
And
Thank
thank
you.
you for always dressing appropriately for court.
Thank you, Your Honor.
All right, good morning. And state, were you able to tender an offer?
Yes, Your Honor. An offer has been extended to Mr. Norton.
That is correct, Your Honor.
All right, your plea deadline date is going to be June 27th. At that time, you need to let the court know whether you all have come to an agreement. If you don't come to an agreement, your next setting will be a jury trial date. Does everyone understand?
Yes, ma'am. Sure.
Yes, ma'am.
Good morning. All right, so you're going to come back. State, were you able to tender an offer?
Yes, Your Honor. An offer has been extended to Mr. Nesbitt.
All right, your plea deadline date is going to be June 27th. On that date, you need to let the court know whether you all have an agreement. If you don't come to an agreement, then you will have your jury trial date as your next setting. Does everyone understand?
Yes, Your Honor.
Yes, ma'am.
All right. Once you sign the reset form, you're excused.
Thank you, Judge.
Thank you. Thank you for dressing appropriately for court.
Your Honor, may the state be excused.
Yes. All right. And so this case, I'm looking at the docket. There are a lot of cases.
We have plea agreement,
Oh,
Judge, but we can't do paperwork.
ah,
So I think if we just, I don't know when we're gonna,
all right. So what I'll do is I will recall it.
it's for time anyway, so it's not like it's.
You'll have to do another couple and a half weeks, Judge, and I'll be out. I can certainly appear by Zoom, but I'll be out next week, out of town, that is. If we can do it the old Zoom way, that'd be fine. But
All right. I don't know. Do y'all want to do it by Zoom?
Well, Judge, I mean. I
Because
don't know
it will
if-
be difficult because still need to do the
Right.
paperwork.
If we can set it off before Bob comes back,
All
I
right.
think that should be better.
When will you be back?
the week of the 10th, Judge.
All right. So you all want to set this for. Let me see. You want to set it for June 11th?
We can do that, Judge. Is Monday not available?
Oh, no, we can do it on the 10th, but sometimes when people are coming back on a
Yeah.
specific day, but you want to do it on the 10th?
No, the 11th is fine. You're right about that. That's
All right.
give
So
me data.
we'll be back on June 11th for disposition.
Thank you, Judge.
You're welcome. Deputy Laura, he can go back.
And focus on his way.
Are we really not gonna be able to do pleas till the system comes back up?
Oh, yes, that you can tell there was great
And that
planning
is-
that went into this.
That doesn't make any sense at all.
All right. Court is calling 2023 CR 11529, State of Texas versus Abel Martinez. Can I have parties announced for the record for the state
Daniel is for the state of Texas.
defense?
Hey, Dan Kramer.
Are you Mr. Martinez?
Yes, ma'am.
All right. The reason why you were appointed an attorney is because the court received a report that there's a request for restitution. And I wanted to make sure that you had an attorney for this hearing. Ms. Kramer, are you prepared to proceed?
Based on the information that I was provided, it seems fairly simple. So yes, I'm ready to go.
All right. State. All right, any objection to the court reviewing the documentation?
Not at all, Judge.
All right, so the court is reviewing the documentation and it shows that there was a transaction, an ATM withdrawal on August 17th at 17:02 for $500 and another withdrawal from the ATM on August 17th at 17:03. Both of those withdrawal amounts, I'm sorry, were $500 each. And what is does anyone know the alleged time that this offense occurred from the stipulations?
I just have the supplemental, so that would have to come from the state.
If there are no objections, I'm looking at the supplemental. And the supplemental, they have August 17th as the offense date. And in the stipulations, it says the occurrence of the event was 1845 with end time of 1935. So,
On the same day?
yes.
But that, what is that, like 6:30 to 7:30?
Well, the complainant is showing a withdrawal from the ATM on August 17th at 17:03.
And that's
And-
like 7 o'clock?
That's 5.
PM? Okay.
Yeah. And then the incident, according to what's in the stips, it has August 17th and the time frame is 1845, which would be 6:45, and the end time is 1935. Yes.
Okay, and Judge, if my turn? I don't know if it's-
Yes.
As far as the supplemental, I think it says 1,200. In any event, I mean, circumstantially, we don't have any real proof that this money was in the glove box. Anybody could basically, say, oh, I want this money, I put it in the glove box, and, we don't have any idea if it was taken or not. I would think that there should be more than just some, I don't know, unsworn statements from them that this money was in the glove box, alleging that he took it. Secondly, as to the proof from that the insurance company didn't cover the window replacement of 450, documentation of that would be nice. I haven't seen anything like that where the insurance company did not cover that. So barring that, I would say that the court should, at least not at this point, order the payment of the 450 either.
All right. So with regards to the $1,000, which is the ATM withdrawal of 2 ATM withdrawals, $500 each, the court is going to order the restitution for the $1,000 for the ATM withdrawals. With regards to your argument about what the insurance did not cover, do you have any proof of that?
Judge, I can look in discovery.
All right. If he is able to provide that, then the court will hear any arguments for why the court should not consider it counsel.
And so at this point, it's not ordered and we'll have to have another restitution if it gets provided.
Yes.
Thank you, Judge.
All right. So you're going to be ordered to pay the $1,000 restitution to the complainant. Do you understand?
Yes, ma'am.
All right. Is there anything else?
No, Judge.
All right.
Thank you,
Thank you,
ma'am.
Ms. Kramer. Yes. And Ms. Kramer, make sure that you receive the appointment order.
Yes, I don't think.
If you
Norma's
can come
not here
back
yet,
this
I'll have-
afternoon.
Okay.
All right. Thank you.
Hire an attorney. If
All right.
possible.
No, I mean, we've been here since September 7th. So we're going to go with who's here.
Let's go.
All right. So is this going to be contested?
Let me talk for a second.
All right, if y'all will step back
Yes, ma'am.
and just let the clerk know when you're ready to approach. All right, court is calling 2022 CR 7549 State of Texas versus Devin Strike. Could I have parties announced for the record for the state?
Jason Garrett.
Vince?
Adam Hood for the defendant, Your Honor.
All right, and are you Devin Strike?
Yes, ma'am.
All right, you entered a plea on September 5th of no contest. And there was a request for a PSI and TAP evaluation. According to your plea bargain agreement, the state is recommending deferred adjudication. Have both parties had a chance to review the PSI report?
Yes, Your Honor.
All right, any objections to the PSI report?
No, Your Honor.
No objections. Just one question. They said a DDRF and mixed screening was set for, I believe, today, say the 26th.
Yes.
I didn't know that was done. That's, other than that, it's not an objection, Your Honor. I was just curious if it was completed.
No, if it's scheduled for today, It's not completed.
That would make sense.
Yeah, no problem. So have you had a chance to review the TAP evaluation as well?
I have, Your Honor.
Any objections to the TAP evaluation from either party?
No, Your Honor. Nothing in the public defense, Your Honor.
All right. Anything you wish to say on behalf of your client?
Yes, Your Honor. We're here. Mr. Strike, he took responsibility for the action. He acknowledges he messed up, Judge. We're hoping the court will grant him deferred. Obviously, he completes it, and have a very good outcome for him. Let him avoid a felony record and felony conviction for the rest of his life. He messes up, he's facing up to 2 years in state jail, which is day for day. He understands how serious this is, Your Honor, and respectfully would ask the court to follow the plea and grant him deferred adjudication today.
All right, Mr. Strike, is there anything you wish to say?
No, Your Honor.
All right, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand. State your name for the record.
Devin Strike.
All right, do you have any support system, family, or are you just on your own?
I have a support system.
I'm sorry, who?
I have a support system.
All right, who's your support system?
My mom, my girlfriend.
All right, do you live with your mom?
No,
Who do you live with?
my girlfriend.
All right, and how old is she?
I'm 28,
All right, and how old are you?
21.
All right, do you all have children?
Yes, ma'am.
All right. I remember this case. That's why I asked you that. So if you're drug tested today, what are the results going to be?
Negative.
All right, when's the last time you used?
Never. Well, not never, but a long time ago.
Well, I mean, you're, so you're saying that you haven't used and you were not using the drugs that you're here for today?
Hmm.
You're gonna have to say yes or no.
No, ma'am.
Are you employed?
No, ma'am.
So you're not supporting yourself.
No, ma'am.
So how are you surviving? And when I say surviving, if you don't have employment, you have to eat, you have to drink water or drink something, you have shelter, obviously. So how are you supporting yourself? How do you eat? And when I say how do you eat, how are you getting food?
My girlfriend.
All right. And how old is the child?
She's 5 months.
And is she in daycare or what?
You know,
So where is she now?
at home.
With your girlfriend?
Mhm.
Okay, you need to say yes or no. And does your girlfriend work?
Yes, ma'am.
And what does she do?
She works from home.
Why don't you have a job?
Because I'm waiting on a disability check to see if I'm qualified.
All right, have you put in for disability?
Yes, ma'am.
And what's your disability?
I have schizophrenia.
Okay. All right. Did anybody see whether or not he would be a good candidate for mental health court? Was that even looked at? And the reason why I'm asking, I see his criminal history, but let me just tell everybody what my concern is. My concern is, obviously, there's an issue with him staying on his medication. We have a 5-month-old at home. The girlfriend works. I'm not saying anything will happen with the 5-month-old, but I think we all know things can happen with a 5-month-old if you have somebody with schizophrenia. And I do not have the support to monitor him the way mental health court would monitor him, or to monitor him, with probation. They can only do so much because they have a heavy caseload. And if he's in mental health court, they can do more. So that's my concern. So I don't know if anybody else has those concerns. I don't know if anybody wants to see if he would be accepted in mental health court.
What would be involved in that, Judge? I'm not too familiar with the process.
Oh, they report weekly to mental health court.
Okay.
They would probably get a case manager, which he needs a case manager to make sure he stays on his medication. Are you on any medication?
Yes, ma'am.
All right. Do you have a case manager?
No.
He needs a case manager to make sure he's taking his meds. And this has just been my experience in having clients who had mental health issues, is that they start feeling great, then they stop taking their medications. And the reason why they stop taking their medications is because there are side effects and they don't tell their doctor about it. And then the next thing you know, my client will be back in court for another criminal case because they're not on any medications. So that coupled with he's trying to get SSI for his mental health issues, the mental health court would have people that would be able to help him with that. So I don't know if you all want to discuss that. I don't know if, based upon his history, state if you want to consider that or not.
I haven't looked at his history of late, Your Honor.
All right, well, what I see on this is there was a misdemeanor assault case, evading to detention, and he received probation for both of those, and probation in the assault case, and it was dismissed, I'm assuming because he completed probation. And then the evading arrest, his probation was terminated. And then resisting arrest, probation was terminated. And then we have this.
Yeah.
So I don't know if y'all want to look at that. I don't want to set him up.
Well, the state wouldn't be opposed to this.
Okay, because I don't want to set him up for failure.
We're not opposed, Judge.
All right, so if you will go, Ms. Ferguson, can you see if they can do a referral for mental health court for him? And then we'll reset it, do a referral for mental health court. And then if he's accepted to mental health court and you all want to do a motion for new trial, we'll hear it. And if there's no objections, then, because they don't accept you if you have
A plea.
any case, yes.
Okay.
All right, Adam, if you will wait, Mr. Strike.
Hold on.
Hi. So do you understand what's going on?
Not completely.
All right, so
I'll talk to
you'll
him.
talk to him?
Yeah.
All right, and if you could tear up the trial court certification for me.
We're gonna TIC some cases as part of our agreement, so that's the only thing. Yeah. Okay, so we're not gonna hear the rest?
Not that I know. I mean,
Oh, okay. Yeah.
All right,
We're ready, Judge, sorry.
all right, did you all do a trial court certification?
I know that's all.
Oh, it's over on the wall.
All grasses and all. Everything is signed, but
I really, kind of depends on the weather's doing. Yeah, Raggy was got behind Jiggy, so and the mold slide. I'm. Where do you?
All right, thank you. Court is calling 2022 CR 2006 State of Texas versus Christopher Ryan Chandler. Can I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense.
John Robertson for Mr. Chandler.
And are you Mr. Chandler?
Yes, ma'am.
Right. I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am, I do.
Are you the same Christopher Ryan Chandler who was placed on deferred adjudication in 2022 CR 2006 for the offense of evading arrest detention with a vehicle on June 16, 2022 for a period of 2 years? Is that you?
Yes, ma'am.
All right, state.
This is on the supplement, Judge. It's
Just 1 second. I don't have a supplement. All right, I'm going to show you what's entitled State's Motion to Supplement Pending Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that as well, Mr. Chandler?
Yes, ma'am, I do.
And did you understand it?
Yes, ma'am, I do.
All right, state.
Violated condition number 4 in Bexar County, Texas, the defendant, Christopher Ryan Chandler, did then and there fail to report to the supervision officer as directed for the months of February, March, April, May, June, and July 2023 in violation of condition number 4.
How do you plead to that? True or not true?
True, ma'am.
State.
Your Honor, we waived the other violations alleged in the motion to enter adjudication.
Any objection?
No, Your Honor.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine?
Yes, ma'am. I was.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, ma'am.
Court will find violation of condition number 4 true. Is there a proposed agreement?
Yes, Your Honor. Your Honor, we're asking, the defendant is, we're asking you to adjudicate the defendant guilty. We're going to dismiss the underlying violations alleged in the original motion to enter adjudication of guilt, and 4 years to do, Your Honor.
All right, is that the agreement?
It is, Your Honor.
Are you asking the court to follow that agreement?
Yes, ma'am.
Are you waiving your right to appeal?
Yes, ma'am.
All right, then the court will grant the motion, find you guilty, sentence you to 4 years in the prison, give you credit for any time served, all right, is there anything else with regards to sentencing?
Yeah.
I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. You understand? All right, we can go off the record. How old are you?
24.
You're going to have to start living your life better. Otherwise, you're going to find yourself in and out of the prison. You understand?
Yes, ma'am.
Don't be that person who's the oldest person at the prison. You understand?
Yes, ma'am.
All right, good luck to you.
Thank you.
Sure. All right, the court is calling 2020 CR 2272, State of Texas versus Megan Hayes Wilhite. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense.
Kelly Piddle.
And are you Megan Wilhite?
Yes, ma'am.
Am I pronouncing your last name correctly?
Yes, ma'am. Will Height.
All right. I'm going to show you what's entitled Motion to Revoke Community Supervision and First Amendment Motion to Revoke Community Supervision. Did you review those documents with your attorney? Did
Yes,
you
ma'am.
understand them?
Yes, ma'am.
Are you the same Megan Hayes Wilhite who was placed on community supervision in 2020 CR 2272 for the offense of burglary of a habitation force on August 29, 2022 for a term of 6 years? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 4 in Bexar County, Texas. The defendant, Megan Hayes Wilhite, did then and there failed to report to the supervision officer as directed for the months of April, June, and July 2023 in violation of condition number 4.
How do you plead to that? True or not true?
True, miss.
And Judge, this is going to be on the first amended motion to revoke. It's violated condition number 1 on or about the 26th day of September 2023 in Bexar County, Texas. The defendant, Megan Hayes Wilhite, committed the offense of theft in violation of condition number 1.
How do you plead to that? True or not true?
True, miss.
Your Honor, state waives all the violations.
Any objection?
No.
All right, did you understand by pleading true to violations 4 and 1, the court could find it true, grant the motion, and sentence you up to 10 years in prison? Did you understand that? And up to a $1,500 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violations 4 and 1?
Yes, ma'am.
Court will find violations 4 and 1 true. Is there a proposed agreement?
No, Your Honor, we were going to go open to the court. The state was going to recommend 6 years TDC.
All right, so the state is asking for 6 years defense?
Judge, I don't know if she was just sworn. Can I have my client testify briefly?
Yes. Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand if you'll state your name for the record.
Megan Hayes Wilhite.
All right.
Megan.
Just one moment. There's Rattling. All right, who are these people? Are they on the docket? The only people who are allowed in the courtroom are defendants. Sorry about that.
It's okay, miss.
Megan, you understand the state is recommending that you go to prison,
Yes, sir.
and you're asking the court to send you to safety.
Yes.
Why?
I want the opportunity. I haven't been able to get any kind of help when it came to drug rehab, and I really do want the opportunity to be able to get clean. I think it's about time that I do something good with my life, and I believe that safety would be a reasonable option for me to be able to get clean and do the best I can for myself and my family.
What is your drug of choice?
Marijuana and methamphetamines.
Okay. When did you first start using marijuana?
When I was about 14, 15,
When
and
did you start using meth?
methamphetamines about 32 years old,
How old are you now?
38.
Have you ever received any type of outpatient or inpatient treatment?
No, sir.
In regards to the reporting, you didn't report for those months. Why?
I did not have a vehicle, and I had my belongings taken from me, from an individual that I was living with, my phone, everything, all of my email addresses and everything had been changed up. I had no way to contact anybody. And I was just scared to go up to the probation office at that point. I already knew that I had MTR'd, and I was just scared.
Okay. You understand that you could have gone up to probation at any time and they would have helped you and probably assisted you in getting your identification and that type of stuff, right?
Yes,
Okay,
sir.
but you didn't do that, right?
No, sir.
So you were placed on probation when, like last year in August?
Yes, sir.
Okay. You didn't receive any type of treatment?
No, sir.
Okay. And so you're asking for it because you don't want to use methamphetamine.
Most definitely not.
Passwords.
State, any questions?
Just a couple, Your Honor. Ms. Woolhite, you did have an opportunity to review the court summary, is that correct?
Yes, sir.
And did you see here that this isn't your first MTR?
Yes, sir.
And isn't it true that at the last MTR, you were told to go to outpatient treatment and that was a part of one of the conditions?
Yes, sir.
And you didn't go?
I don't think that the outpatient was available at that time. They had told me that I was taking classes, but that wasn't, I guess in the, how would I explain this? They had me doing certain things at a certain time, and I'm sorry, the outpatient wasn't at that time that I was going. I was going to classes downtown, but it wasn't treatment at that time.
Pass the witness, Judge.
No further questions.
All right, I have a question. What classes are you saying you were going to downtown?
I was going to the theft classes.
All right, so what are you saying happened with outpatient treatment?
I hadn't gone to the outpatient treatment yet.
All right, why not?
I had been working and I didn't have time to do it at that time. I hadn't been able to make time yet.
All right, so this is what I'm trying to get to. One, was outpatient treatment ordered for you? Yes or no?
Yes, ma'am.
All right. Did you do outpatient treatment? Yes or no?
No, ma'am.
What is your reason for not doing outpatient treatment?
I was, like I said, I was working at the time. I didn't have the time at that period of time. I was going to be making time for it, but I did not have the time at that period of time.
All right. Because, and the reason why I asked that question, because, and if I'm wrong, everybody can let me know I'm wrong. I'm going to take that as a sign of disrespect, but it seems as though you were saying that outpatient treatment wasn't available when the state was questioning you. Did I hear that incorrectly?
No, ma'am. No, not that it wasn't available. It's whenever I was with Ms. Martha Reyna, we were setting everything up. She had me doing the classes at that time, and I hadn't been able to do the outpatient treatment yet. Not that it wasn't available, because it was part of my agreement, but it just, she had me doing the classes. I was checking in and everything like that with her, doing my UAs and everything. I just hadn't done the classes yet for the outpatient treatment.
Okay. All right. Any other questions?
No, Judge.
No, Judge.
All right. Probation.
Yes, Your Honor.
What is probation requesting?
Your Honor, the recommendation on the court summary is if she is not revoked, then to send her to safe P. I would like to point out this is her second MTR. And as she stated, it looks like she may have maybe entered the theft classes, but they were never completed. So, at least we don't have record that they were complete.
All right, anything else from either side?
Just brief argument. Judge.
All right, then I'll hear argument state. You are requesting 6 years.
Yes, Judge.
Is there anything you wish to add?
Judge, it's just, she's been given plenty of opportunities to attend treatment. Even when answering the questions on treatment today, she didn't really give an answer, other than she didn't have the time to do it. She's been given chance after chance. That's why the state's recommending time in TDC.
All right, defense.
Judge, the purpose of probation is to rehabilitate individuals. I understand this is Ms. Wilhite's second MTR, but if she's given an opportunity in safety and she's able to no longer use methamphetamines in the future, then that's the win, that's the purpose. And if safety is successful, then she'll be able to complete the rest of her probation. If it's not successful, she'll be back here and you send her to 10 years TDC. So we're just asking for that opportunity to try to get her to treatment so she doesn't continue to use methamphetamines.
All right, anything else from you, Ms. Wilhite?
No, miss.
All right, Ms. Wilhite. The problem is, it appears that you have started things, but you have finished nothing. And the problem is, you were given a chance at outpatient treatment and you didn't take advantage of it. I could understand if you did outpatient treatment and it wasn't working. And everyone who comes into this court who's on probation, know I always say, if there's an issue, if there's something you have a problem with, if you feel probation isn't addressing it, you can always come to the court and say, Judge, this is not what they're addressing. Judge, I have a drug problem. Can you help me with that? Judge, I have mental health issues. Can you help me with that? We have an open door policy here. You can always come in and ask for that. But you haven't taken advantage of that. I'm going to grant the motion and revoke you. The state is asking for 6. Defense, what are you requesting?
Judge, we're asking for 4.
Okay. All right, I'll sentence you to 5 years in the prison. Give you credit for any time served. Is there still restitution owed? Because there were several people
Yes,
that
ma'am.
restitution was to be paid to.
Yes, ma'am.
So did they ever put in any amounts of restitution that were due?
No, no.
All right, so they didn't put in any amounts, so I don't have any amounts, and if they want to do something with that later, they will have to take it up as a civil matter or somewhere else, but this court is not going to put it in the orders because I don't have anything. There's still to be no contact with the complainants that are previously listed. And let me write those down. If you would like, what I can do is I can recommend for you the therapeutic community. I am not in charge of whether or not they give you or place you in the program. You'll have to still request it, even though I put it on the form recommending it. It will not increase the length of time that you are in custody. So for example, if you're coming up for parole in 2 years or whatever, and you have not completed the therapeutic community portion of it, they're not going to say, well, we're going to give her parole, but since she hasn't completed the therapeutic community, we're going to keep her. That's not the way it works. It's just there for you while you're there. Would you like that?
Yes, ma'am.
All right, so I'll order therapeutic community. You're still going to have to ask for it, okay?
Yes, ma'am.
I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
All right. Because this is not a plea bargain agreement, you do have a limited right to appeal, and that right to appeal is as it relates to the allegations in the motion, not the fact that you were on probation. And state has tendered dismissals in the misdemeanor cases that are pending. All right, is there anything else?
No, ma'am.
That's it.
All right, good luck to you, okay? You're
you.
welcome.
You, Judge.